into the constitution as applicable to the state of Jammu and Kashmir
only.
by CA 48 of 1954.
Correct. So constitution was amended, which was 370. You can amend the constitution or you can apply existing provisions.
Under 370, a CO was issued and which brought in a sense, 35.
Correct. But as I pointed out, whenever the situation required it, 370 remained floating. Whenever some changes were required, depending upon the circumstances, they were made through the mechanism of 367. 367 is an interpretation clause. So the interpretation was made.
At that time, there was no legislative.
No, it was, my lord, to be made immediately. Therefore, my lord, in advance, my lord, they must have made a provision. There was none, my lord. This is 54, so there was none. Because the constitution was framed in 57.
So in terms of giving representation to the state in other forms, it would require Constituent Assembly to be interchangeably used so that till the Constituent Assembly finalize something, it would not...
No, my lord, another purpose is that till the legislative assembly comes, somebody will have to make laws other than constitution. They were made. The Constituent Assembly after this functioned as a legislature of Jammu and Kashmir also. And they made other laws also. I have given the list.
It was primarily to ensure enforcement of 370 articles of clause 1, which power was vested with the Legislative Assembly. So they vested it with the
Constituent Assembly, so that laws can be made by the Constituent Assembly. Otherwise, my lord, Constituent Assembly is not a law-making body in that sense. Of course, my submission is that Constitution of Jammu and Kashmir is at par with a legislation only. It's not, my lord, a kind of a constitution as we understand, my lord, as a document of governance. The State Reorganization Act comes. It does two things. Lord, one, Part A and Part B states are clubbed into one called states. So Jammu and Kashmir ceased to be Part B, but it became a state like any other state. And Part C states became union territories. That is first. So A and B became states and C and D became union territories. We are not concerned with that right now in this matter. Second was the identity of princely states was completely abolished. Till then, till 56, the Raj Pramukh was the erstwhile princely ruler. This was abolished. That now, henceforth, it would be the governor appointed by the President of India. The President who is responsible to the Parliament and the Parliament who is responsible to we the people of India. So now, no Raj Pramukh who is the princely state. He can be appointed as a governor, that's one thing. Some of them were appointed, but not by virtue of they being a member of that lineage in the princely states. But this happened. But at this stage, Article 238 was repealed, rather omitted, not repealed, it was omitted by 7th Constitutional Amendment. 1711-56, the Constitution of the state of Jammu and Kashmir is framed. The document called Constitution of Jammu and Kashmir is framed. That's all. I have, my lord, given excerpts from the debates which essentially says that Jammu and Kashmir is an integral part of India. I don't think that is something which is not required to be labored much. Therefore, I am not skipping.
That also.
Yes, therefore, I am skipping that. The second use of the mechanism under Article 367. Your Lordships would recall, in the first use, the Honorable President said Constituent Assembly and Legislative Assembly are used interchangeably. But at this stage, the Constituent Assembly ceased to exist because the Constitution was framed.
Phraseology used was governor henceforth from this.
Yes, henceforth it was governor.
But the phraseology used to head of the elected government as Prime Minister did not cease with this.
I beg your Lordship's pardon.
Chief Minister used to be called the Prime Minister there.
Yeah, that went, my lord, after Sadr-e Riyasat itself. It became Sadr-e Riyasat. Prime Minister went. It became Sadr-e Riyasat and thereafter, my lord, Raj Pramukh and thereafter governor. Now it remains governor throughout thereafter. But in these very proceedings, when there was a request for a reference to a larger bench, in this very petition, Lord, the 5-judge bench, Lord, speaking through my Lord Justice Kaul, exactly said this, that it may not have bearing on the either side. Now, my lord, page 69. Now, my lord, the integration of judiciary. Slowly, my lord, some provisions came to be applied, truncated, some full, some modified, some with exceptions. But Article 222 was made applicable regarding transfer of judges. Earlier, my lord, till 60, the honorable judges of the High Court were not transferable by the Supreme Court. But the oath was prescribed, and till 2019, the honorable judges of Jammu and Kashmir High Court used to subscribe to this oath. My lord, please see. Oath or affirmation to be made by judges of the High Court. I, Shri So-and-so, having been appointed Chief Justice or a judge of the High Court of Jammu and Kashmir, do swear in the name of God, solemnly affirm that I will bear true faith and allegiance to the Constitution of the state. Though they were, my lord, under an obligation because of Article 1, and they were applying the Constitution of India. But the oath which they used to take was expressing their allegiance to the Constitution of Jammu and Kashmir state. Even the Honorable Chief Justices, my lord, who would be appointed there, would be taking this oath. That's it, my lord. Nothing beyond.
Just as an aside, Malad, during these debates, Malad, Pandit Jawaharlal Nehru intervened and he said, if you talk about outsiders buying land in Jammu Kashmir, I am totally opposed to it because big business will come in, Malad, and will destroy the entire state completely. So he was very adamant on that.
That was a mistake, my lord.
I'm sure it was a mistake. I'm only saying those
That
parts,
was
those
my
parts
lord,
should also
that is
be
right.
read. Those parts, I'm not saying
That, my lord.
everything that we did was always a mistake. Malad.
No, I'm not being political, my lord. I'm from citizens' point of view. Unless investment comes, you never develop.
Why it did not culminate into something?
Just for the record, for that debate, 23 for, 157 against, 160 pages of debate. Guzari Nanda says that you cannot change 370 till you follow 370. So all that, well, what is happening is we're expanding all this, which is not part of
Which I may assure my learned friend.
Well, at least you should point the facts out.
Lord, there is no intention, my lord. Everyone, we were led by eminent people. Everyone contributed. There is no, my lord, undermining the contribution of anyone. The only purpose was voting may differ. This was the view consistently explained, and my lord, my only purpose of reading was this is how the country treated it as temporary. That's all. My learned friend may take any other meaning out of it. Everyone contributed, but even 370 must have come with good intention of integrating the nation. The purpose of reading the debate was, and is, my lord, I'm not reading it now, that it was conceived from the beginning as a temporary provision. That's all, my lord. Not to undermine anyone's contribution. So if an authority contemplated under Article 370 ceases to exist, it can be replaced by the successor or the closest possible successor under 367.
CEOs, in fact, were amending Article 356 because that prescribes 3 years. President's rule.
I'm sorry.
These were then extending the president rule as prescribed in the Article 356 because the period prescribed is 3 years maximum.
But it kept on being extended by the parliament.
CEOs, it was extended from 3 to 4, 4 to 5.
It can go up to 7, Manoj, because parliament will have to then extend it. Because situation was, Manoj, it was an extraordinary situation. During that period, it was at the...
No, I'm not on that. That the power to amend was excised in terms of 356, notwithstanding the proviso to...
Yes, your lordships are right. That was the...
368, notwithstanding the proviso to...
Yes.
But the body is challenged? No, they were never challenged.
No, not challenged.
Can you invoke section 92 after Article 356 was made applicable?
No, Article 356 came subsequent. Yes.
Nobody raised that issue.
But subsequently 356 comes. So if there was, I understand, Manoj, the query. Even if there was an irregularity which is caught subsequently by 356. After 6...
I'm even saying that.
But your lordships are right. That is the reason why ultimately I would show, my lord, the constitution of Jammu and Kashmir required to be repealed because it can never coexist. Once you apply the entire constitution, you cannot have a situation where there is a separate document of governance operating. It was, my lord, according to me, it's a separate argument, a piece of legislation, but your lordships are right. They have been directly under 356. Your lordships are absolutely right.
And Mr. Solicitor, when you say the contradiction, the very fact that you invoke section 92,
92.
and not 356, you're accepting that both of them can coexist.
Require 92, yes. Otherwise, my lord, there are several provisions which I'll be able to demonstrate. But, my lord, in any case, that's my lord, a separate submission on that, my lord. Why, how Jammu and Kashmir constitution would not exist the moment, my lord, 370 sub-article 3 is invoked. But your lordships are right.
You can argue, but other way also, there are other arguments available to make that argument.
Correct.
Or that submission.
Today, there is no challenge to the dissolution of the assembly. The petitions which were filed after 5th and 6th
that
of...
resolution also takes place in the Constitution of India as applicable to Jammu and Kashmir.
Your lordships are right. The petition which Mr. Sibal argued Muhammad Akbar loan is a petition filed by two members of parliament belonging to National Conference, Muhammad Akbar loan and another member. No challenge either to the governor's rule, president's rule, or dissolution of legislative assembly. One IA is filed by the former chief minister, argued by Ms. Ramkrishnan, in 2022, IA for impleadment. So, no political party challenges either governor's rule or president's rule or dissolution of assembly contemporaneously. Dissolution not challenged at all. Otherwise, your lordships are aware, my lord. Your lordships are disturbed even at the middle of the night that now we are ready to forge an alliance and we are ready to form a stable government. Because there were several arguments were made on that how can the assembly be dissolved like that? I am just, my lord, pointing out the hollowness of that argument.